This tutorial is going to cover the laws governing individual insolvency. There are several methods to consider in this area. The first, which we are going to cover, is bankruptcy. Individuals, being partners or sole traders, risk personal bankruptcy if they are unable to pay their debts as they fall due. Bankruptcy is designed to grant relief from debt for an insolvent individual and enable a fair realisation and distribution of their unsecured assets. The laws of bankruptcy are mostly contained in the Insolvency Act 1986. Bankruptcy commences on the making of a bankruptcy order against an individual who is unable to pay their debts. A petition for a bankruptcy order can be presented by the debtor personally, a creditor, whether secured or unsecured, supervisor of or a person bound by a voluntary scheme, or the Director of Public Prosecutions. Looking at these methods of commencement in turn, if a debtor wishes to declare themselves bankrupt, they must do so by making an online application to the adjudicator. The debtor seeking bankruptcy must complete the form with personal and financial information before paying two fees: for adjudication of their application and a bankruptcy deposit, which is to cover the cost of managing the bankruptcy.